He's on a quorum being present, the Subcommittee on Workforce Protections will come to order. Good morning. Let me begin by welcoming our guests and thanking our witnesses for joining us today. We'll discuss a number of legislative proposals that would bring greater transparency and accountability, I trust, to the Equal Employment Opportunity Commission. We're here because every member of this committee recognizes the EEOC as a vitally important agency. It has a responsibility to protect the right of all workers to a fair shot at employment opportunities and a workplace free of discrimination. That's what America is about. This is a fundamental human right each and every one of us holds dear. No one should be denied a job, have their wages cut, or passed over for a promotion because of their race, their gender, religion, or disability. We are here because we want the EEOC to do its job, and more importantly, to do its job effectively. That's why in recent months we've made oversight of EEOC a priority. Because we know men and women are being discriminated against. We know bad actors would rather put their own hateful prejudice before the talent and the experience of each individual worker. It isn't right, and it is EEOC's mission to help stop that from happening. Unfortunately, in recent years, the EEOC has shifted its focus away from that vital mission. Instead, it has spent a great deal of time and resources advancing a deeply flawed enforcement and regulatory agenda. Employers have fallen under EEOC's intense scrutiny without any allegation of employment discrimination. Charges are being filed in federal court with little to no evidence of wrongdoing. Federal judges have harshly and appropriately criticized the agency for its shoddy legal work. Each day, the agency harasses employers without cause, and every case tossed out of court for legal malpractice is another lost opportunity to help victims of employment discrimination. It means the veteran, the injured and disabled, while serving our country, will continue waiting for his or her day in court. It means the single mom who worked long and hard to earn a promotion will continue waiting for her day in court. More than 70,000 individual complaints are sitting in front of the Commission. The backlog represents thousands of private sector workers who believe their rights were violated and who are waiting anxiously for the Commission to do its job. As the old saying goes, justice delayed is justice denied. It's time to stop denying these men and women the justice they deserve. Not only is the EEOC dropping the ball with its misguided enforcement priorities, it is also pursuing a regulatory scheme that is making it more difficult for employers to protect employees and consumers. In recent years, states and localities have adopted policies to protect Americans in vulnerable situations that come in contact with workers, such as at home and in the classroom. The EEOC has eviscerated these efforts. Quite simply, the agency's edict restricting the use of criminal background checks is putting people in harm's way, including women and children. It's time the agency changed course, and that's precisely what the legislation before us is intended to do. Among other provisions, the proposals will help shine more sunlight on EEOC activities, compel the agency to work with employers in good faith to resolve complaints, force the commissioners to do their job and oversee the agency's enforcement actions, and provide a safe harbor to employers complying with federal, state, and local mandates, such as laws requiring criminal background checks during the hiring process. These are common sense reforms and should enjoy overwhelming bipartisan support. By supporting the legislation, you're supporting transparency at a vitally important federal agency. By supporting the legislation, you are supporting the ability of states to promote a safe and responsible workforce. By supporting the legislation, You are supporting an effort to get this agency back on track to better protect the rights of America's workers. I urge my colleagues to support a more effective, accountable, Equal Employment Opportunity Commission by supporting this legislation. I would like to thank my colleague, Representative Hudson, for his leadership on this important issue. Again, we are grateful to our witnesses for joining us, and I look forward to our discussion. Before I recognize the senior Democrat of the committee, I would like to ask for unanimous consent to include in the record letters from interested stakeholders supporting the bills we are discussing today, including letters from Kinder Care Learning Centers and the Early Care and Education Consortium in support of H.R. 5423, the Certainty and Enforcement Act of 2014. With that, I will now yield to my friend and colleague, Representative Joe Courtney, for his opening remarks.
Thank you, Chairman Wahlberg, and thank you to all the witnesses for finding time to join us here today. And again, at the outset, just so I don't forget, I would just ask unanimous consent to submit a statement from Congresswoman Marcia Fudge, who's over at the Agriculture Committee. They're having a hearing today that conflicts with her attendance, but she was very adamant. She wanted to make sure her passionate comments are entered for the record. Hearing no objection and appreciating these comments, they will be entered. Thank you, Mr. Chairman. Mr. Chairman, this summer we celebrated the 50th anniversary of the 1964 Civil Rights Act, one of the most significant steps in the fight for equality in this nation's history. Title VII of this landmark law outlaws workplace discrimination on the basis of race, color, religion, sex, or national origin. These provisions help ensure that American workers are judged on the work they do, not on who they are, where they're from, or what they look like. Yet even with all the progress we've made in the last 50 years, there is much more work to be done. Too many Americans suffer from discrimination by their employer even today. For example, just last year there were nearly 100,000 new charges of discrimination filed with the EEOC, including 1,019 Equal Pay Act charges and over 67,000 Title VII charges. I was hopeful when the subcommittee began to examine the work of EEOC last year, we would look at ways to join together to strengthen our civil rights laws and build upon the critical improvements made through measures like the Americans with Disability Act amendments and the Genetic Information Non-Discrimination Act. Instead, I would argue we're wasting time here with a set of misguided bills that impede the operations of the EEOC and attempt to gut Title VII, turning the clock back on civil rights protections enacted more than 50 years ago. These bills would decimate the EEOC's ability to safeguard American workers from discrimination, violate longstanding rules regarding attorney-client confidentiality, and do a great disservice to the nation. We just heard opening comments talking about how justice delayed is justice denied. If you look at what these bills do, and I'm 27 years as a litigator before I came to Congress, in the name of transparency, it would cripple the ability of a client of the commission to deal with their attorney in terms of engaging in any kinds of administrative action or litigation strategy. It would, in the name of oversight, basically force the commission to micromanage every decision in terms of commencing litigation. How that on earth would end delayed process makes any sense. Again, I think just common sense tells you that would add additional steps and delay in terms of the agency being able to execute its duty. And lastly, 5423, which basically turns the Federal Supremacy Clause on its head and puts state laws as a preemptive safe harbor for employers, in my opinion, on the 50th anniversary of the Civil Rights Act, is grotesque. I mean, this is allowing a race to the bottom in terms of states who haven't stepped up and enacted laws to protect people from racial discrimination, from gender discrimination, and those states exist out there, and to basically empower them to override the national commitment that we made 50 years ago to uphold equal treatment under the law for people who are simply trying to get ahead in life and as employees. It's just unbelievable to me. The process that we're engaged in here today, sadly, is par for the course in terms of the way this subcommittee has operated. Our side got notice of this hearing 8 days ago. The 14-day courtesy rule for the commission, which is well understood we know that for the last 3.5 years was definitely avoided by the majority. We get one witness that we can invite to testify, and I thank Mr. Foreman for being here to again, in an imbalanced lineup, defend a position which I think we'll hear loud and clear here today. But what's missing here today is the agency, and all we had to do was frankly pick up the phone and call our side with enough notice, and we could have accommodated that, and actually had a real dialogue today to talk about what's actually happening out there with the department. What I think we're going to hear is that despite all the claims of overzealous litigation and ineffective outcomes, we are going to see an agency which did great work in 2013 in terms of recovering damages for workers who were discriminated against, that the number and percentage of cases that went all the way to litigation is less than 1%. So frankly, we're chasing a problem which certainly from the standpoint of Congress doesn't exist. If there's individual cases out there where people are unhappy with the agency, I think all of us are more than happy to accept those calls, accept that mail, intervene with the secretary. The chairman knows we've had 2 instances this year where we have been successful in terms of getting the secretary to pull back cases of overzealous enforcement of various laws. So it's not like we're dealing with an agency that refuses to respond or listen to reasonable points of view in terms of criticisms of the way they operate. So, I mean, we have 72 hours left before everybody in this building knows we're going home till after the election. So we're bringing up legislation which, it's just not the appropriate response to any of the maybe concerns that people are expressing here today. To actually talk about passing a bill which would short-circuit a case that's pending before the Supreme Court, I mean, it's embarrassing from my standpoint. This is not what Congress should be focused on right now in terms of people across this country who are struggling in terms of advancing themselves, and clearly the middle class and working families are struggling in terms of a tough economy. But frankly, we should be knocking down the last remaining barriers to people that they face in terms of racial discrimination, gender discrimination, age discrimination. That should be the focus of this subcommittee. So again, we look forward to the witnesses' testimony, and again, we hope at some point we're going to sort of realize that we're just sort of grinding our gears here with these types of hearings, and hopefully we can try and come up with a new model, if not in the lame duck session with the next Congress, so that we can, as a nation, take that 50th anniversary and celebrate it the right way, which is to advance equal treatment under the law under Title VII and the Civil Rights Act. I yield back.
I thank the gentleman, and I detect a disagreement between you and me on this issue. But on Constitution Day, we are doing our constitutional responsibility. We have not been given a vacation yet, and I think it is good that we're here, and it's good to have disagreements, and we hopefully can work to satisfactory conclusions, and that means we continually work. It's now my pleasure to introduce our panel of distinguished witnesses. First, Ms. Lynn Clemens is Director of Regulatory Affairs at Berkshire Associates of Columbia, Maryland. Prior to joining Berkshire Associates, she served in several positions at the Department of Labor and the Equal Employment Opportunity Commission, including as Acting Director, Deputy Director of the Policy Division for the Office of Federal Contract Compliance Programs. Welcome. Mr. William Lloyd serves as General Counsel for Deloitte, LLP in New York, New York. As General Counsel, Mr. Lloyd is responsible for managing the organization's legal affairs, including governance, employment, litigation, and regulatory matters. Thank you for being here. Mr. Michael Foreman is Clinical Professor of Law and Director of the Civil Rights Appellate Clinic at Penn State University's Dickinson School of Law in Carlisle, Pennsylvania. Mr. Foreman focuses on appellate representation in civil rights issues and employment discrimination. He has previously served as Acting Deputy General Counsel for the U.S. Commission on Civil Rights. Welcome. Mr. Eric Dreiband is a partner at Jones Day Law Firm in Washington, D.C. From 2003 to 2005, he served as the General Counsel of the Equal Employment Opportunity Commission. Prior to his EEOC service, Mr. Dreiband served as Deputy Administrator of the U.S. Department of Labor's Wage and Hour Division. Welcome. Thank you all for being here. Before I recognize each of you to provide your testimony, let me briefly explain our lighting system, which I think is familiar to you. If you've been on the highway, you've had red, green, and yellow lights. Green gives you your 4 minutes to speak. Yellow gives a warning that a minute is left. And red, we hope that you wrap up your remarks as quickly and concisely as possible. I will hold our committee members to the same in asking questions of you following your statements. Again, you'll each be given 5 minutes to ask the question. We'll be given 5 minutes to ask the questions of you following your 5 minutes of testimony. And so now let me begin by recognizing Ms. Clemens for your 5 minutes. Press the button on your microphone, please, there. Thank you.
Good morning, Mr. Chairman and members of the subcommittee. My name is Lynn Clemens. I am the Director of Regulatory Affairs at Berkshire Associates, a certified small business enterprise that helps other small businesses comply with their equal employment opportunity and affirmative action obligations. I very much appreciate the opportunity to share my perspectives with you today and ask that my written testimony also be entered into the record. For almost half of my career, I served as a staff member at the EEOC and the Office of Federal Contract Compliance Programs, where I joined a dedicated group of career staff who tirelessly work to open the door of opportunity. I have a deep respect for my former colleagues, these agencies, and their mission. It is my experience that employers are similarly dedicated to creating fair and inclusive workplaces and to complying with the multitude of laws that they must follow. This is increasingly a difficult task. On an almost daily basis, I help employers answer real-life questions about their employment decisions and hiring practices. I have a better appreciation now for how difficult it is for an employer, especially a small employer, to understand and comply with the lengthy documents, policy documents, and rules that we publish as regulators. My experiences have shown me that an enforcement agency can only be truly effective when it is respected by the public it serves and regulates. A robust and thoughtful deliberative process and neutral fact-finding are critical to earning that respect. Unfortunately, as an outsider now looking in, I believe that the EEOC has strayed from several of its original good government mandates. Increasingly, I have found that the agency does not always investigate or conciliate in good faith, even though such efforts are statutorily required. I have worked with employers, both large and small, who have endured individual charge investigations spanning several years, surprise notice of a charge by hand delivery with a request for immediate access by an army of investigators, much like an FBI raid, requests for extensive information immediately followed by a predetermination settlement offer that sent the very clear message, pay up or endure a burdensome investigation, and findings of class discrimination without a class investigation. Most employers, and indeed most employees, are surprised to learn that the commissioners do not deliberate on the filing of most lawsuits. Understandably, the public expects that the full force of the federal government will only be brought to bear after careful deliberation. In the case of the EEOC, Congress determined that the deliberative process should be handled by a group of 5 officials with diverse backgrounds, experiences, and perspectives. When I was at the Commission, it generally filed about 400 lawsuits each year. Due to the delegation of authority to its general counsel, also presidentially appointed, the commissioners generally reviewed between 50 and 75 of these litigation proposals. I understand, however, that the current commission only reviews a handful of cases, as few as 15 in almost a recent 3-year period. In the business world, a similar delegation of authority would really be the equivalent of unveiling a new product without the CEO ever even knowing about it. Quite simply, placing the imprimatur of the whole commission on a proposed legal theory garners a level of respect by the regulated community that is simply not possible when decisions are made by a single general counsel or regional attorney, no matter their skill. Perhaps most troubling is the impact on policymaking. Make no mistake about it, the agency is making policy when it decides to litigate. Thus, the process by which the EEOC arrives at those decisions is just as important as whether the agency ultimately prevails. The Commission's efforts in one particular area are instructive. In April of 2012, the Commission issued policy guidance regarding an employer's use of arrest and conviction records. Although this policy guidance was voted on, it was not subject to public comment. Unfortunately, the Commission failed to provide a clear path for employers, particularly those who must weigh the competing interests of the Commission's position and other state and local laws aimed at public safety. What this means is that those hard decisions will now be made through litigation by the Commission, some of which may never be reviewed by the Commissioners before it is voted on. Ensuring equal opportunity is an important federal goal. How this work is accomplished matters, and shining more sunlight on the agency will help it grow and succeed at its mission of ensuring equal employment opportunity. Thank you.
Thank you. Mr. Lloyd, we recognize you for 5 minutes.
Thank you. Chairman Walberg, Ranking Member Courtney, members of the committee.
Not sure your mic is on there.
There we go. Sorry, I'm a novice. Chairman Walberg, Ranking Member Courtney, members of the committee, thank you for inviting me to testify today. I'm Bill Lloyd, the General Counsel of Deloitte LLP. I am grateful for the invitation to testify because today's hearing is focused on a number of bills that I believe would improve the processes within and the accountability of the EEOC. Deloitte is one of the world's largest professional services firms, providing audit, tax, and advisory services to individuals, businesses of all sizes, and to federal, state, and local governments and community organizations. We have roughly 65,000 people in Deloitte, and about 4% of those are the owners of the business, partners. I want to make it clear that Deloitte strongly supports the goals of eliminating workplace discrimination and fostering true equality of opportunity. We also strongly support the EEOC's mission, and we appreciate the dedication of its staff. Deloitte is proud that we have consistently been recognized as a leader in inclusion and in developing highly successful women and minorities in our large firm. Although we are strong supporters of the EEOC's mission, our recent experience with the EEOC suggests that its processes and transparency could use some improvement. We need to ensure that the EEOC enforces its important mandate in ways that are consistent with what Congress contemplated in the respective statutes that the EEOC is tasked to enforce. And we need to ensure that important decisions about EEOC enforcement policy and allocation of scarce resources are made by the commissioners, who are appointed by the President and confirmed by the Senate. The EEOC staff has recently challenged the fundamental structure of Deloitte's business, our decision to organize as a limited liability partnership. The staff has alleged that Deloitte is not a true partnership, and therefore our retirement policy for partners violates the Age Discrimination in Employment Act. The impact of the EEOC's legal theory raises significant economic and policy questions for Deloitte and all limited liability partnerships across the country, which will negatively impact many businesses. Congress did not grant jurisdiction to the EEOC to act on behalf of owners of businesses, yet that is exactly what the EEOC is doing. Deloitte is a true partnership, and our partnership agreements and governance processes reflect that. State professional regulations require that we conduct our business as a partnership. Deloitte's partners voluntarily enter the partnership agreeing to retire at age 62, and each partner is highly compensated both during the period of partnership and after retirement. In fact, many partners choose to retire before age 62. Thus, the EEOC is seemingly advocating on behalf of this group of people in lieu of seeking out true victims of discrimination, the very people about whom Mr. Courtney spoke. For every case of questionable validity that the EEOC brings, it requires that the agency forego many worthy cases of discrimination on behalf of individuals who have fewer resources to pursue grievances and genuinely need the protection of regulators and the government. I'm also concerned by the Commission's extensive delegation of authority to the General Counsel to initiate litigation. I'm not a labor attorney, and I was very surprised to learn that the Commissioners do not review the overwhelming majority of cases filed by the EEOC. After all, Title VII permits only the 5-member Commission to bring a civil action. But my understanding is that in practice, the General Counsel determines whether any particular case is subject to review by the Commission. This practice, in my view, should concern all legislators and taxpayers. In the matter involving Lloyd, the EEOC has been conducting a directed investigation since 2010. We are concerned that if conciliation fails, the General Counsel will file a lawsuit under the delegation of authority without consideration and a vote of the Commissioners, even though a similar matter involving a similar partnership came before the Commissioners last year, and the Commissioners elected not to file litigation. This is not only a matter of great public controversy, but given the powers and rights of Deloitte's partners, it is a novel interpretation of law that the Commission itself clearly should consider and approve before any litigation is commenced. We are not aware of any retired partner who has complained to the EEOC about age discrimination at Deloitte, and ironically, Deloitte's retiring partners are overwhelmingly white males, while newly admitted partners over the past decade have been significantly more diverse. Eliminating the retirement age would ultimately limit the partnerships available to an increasingly diverse population of our employees. I thank the committee for the opportunity to share our perspective, and I'll be happy to answer any questions. Thank you.
Thank you. Mr. Foreman, we'll recognize you now for your 5 minutes.
Thank you, Chairman Walberg, Ranking Member Courtney, and members of the committee for the ability to testify on these pieces of legislation. I am sure there are good purposes behind them, but as my testimony reflects, they are premature, they're unnecessary. I think more importantly, they distort the function of what Title VII was passed to do, and it will thwart any type of effective enforcement of the federal laws. Now, I know 2 of my colleagues that are testifying today, and they both worked at EEOC, and they know firsthand the ugliness of employment discrimination, and they know firsthand that you need to have an effective enforcement agency to fight that evil. They know that. We may not agree on much, but I think we will agree on that point.
Yes, Mr. Klein.
Now, Mr. Dreiband said it best. Notwithstanding EEOC's achievement, we have much work ahead of us. Unlawful discrimination anywhere remains a threat everywhere. Accordingly, we will continue to strive to obtain meaningful relief for victims of discrimination and achieve equality in the workplace. They are his words when he was General Counsel of the EEOC, not mine. They were true then, and they are true now. And these bills would strip EEOC's enforcement ability. For example, the Oversight Act would require a vote of commissioners, a disclosure publicly of that vote, and that vote would be posted within 30 days of starting of litigation. Now, some may say, why is that a problem? Because much of that information is already available. Well, the reason it's a problem because that would create an affirmative defense for every employer in this country. What if EEOC does not post? What if someone challenges the vote? That's subject to discovery. That's not hysteria. That's exactly what's happening in the mock mining case. The employer community is arguing that is an affirmative defense. And what is the remedy? The remedy is the case gets dismissed and the innocent victims never see the light of day. And that's what's troubling about those type of bills. The Transparency Act would take resources, the limited resources EEOC has, and turn them into a data reporting and a website management. There are so limited resources to fight employment discrimination, they should be directed toward fighting discrimination. As Congressman Courtney pointed out, there are obvious constitutional problems with exempting state and local governments from Title VII. I give the example in my written materials that it would basically overrule a case like Griggs versus Duke Power as it applies to state and local governments. It is something we should not be doing at this time. These are basically a remedy in search of a problem. There's no pattern of EEOC abuse. If you look at the number of cases EEOC litigates, they are doing a wonderful job. Their enforcement record should be applauded, and more enforcement agencies should work like they do. There are a few limited cases where they are sanctioned. And that shows that there is a process in place. EEOC is required to play by the same rules of all parties. And if they act improperly in a limited number of cases, Rule 11 exists, and there's a provision of Title VII that holds them accountable and they can be sanctioned. So that shows the system works. We do not need to add another level of sanctions to EEOC thwarting their ability to do their effective job. And then finally, several of the key parts of this legislation are before the courts now. Mock mining has precisely the issue of what does the EEOC need to do in their conciliation efforts and what happens if they do not do it. That case has been briefed. My colleague, Mr. Dreiband, filed a brief this week in support of the business community. The court system has it. The Supreme Court will answer that question, and we will know what that means under Title VII. There should not be anticipatory legislation to deal with that. Similarly, there's litigation in Texas that was filed challenging EEOC's promulgation of the criminal enforcement guidance. Let the judicial system work, and there'll be a determination of whether EEOC had that authority and what that means. Don't short circuit the process. And I would just end, if I could, the Wall Street Journal, in their summary of sort of this issue, made the quote about EEOC, "It's just not saber rattling anymore. The EEOC has shown that it means business." Isn't that the EEOC that Title VII expected? And isn't that the EEOC that every one of us want? One that enforces the law, and these bills would hamper that ability. Thank you for your time, and I'm available to take any questions.
Mr. Foreman, thank you. Mr. Dreiband, we recognize you for your 5 minutes.
Good morning, Chairman Wahlberg, Ranking Member Courtney, and members of the subcommittee. Thank you for inviting me to testify today. My name is Eric Dreiband, and I'm a partner at the law firm of Jones Day here in Washington, D.C. As Mr. Chairman, as you noted, I previously served as the General Counsel of the United States Equal Employment Opportunity Commission, and in that role I was privileged to work with Lynn Clemens and many other talented and dedicated EEOC officials. It is with this background that I appear today at your invitation to speak about 3 bills that are pending before this subcommittee. First, I will start by discussing the Litigation Oversight Act of 2014. This bill would ensure that the EEOC cannot bring major or controversial litigation without a full up or down vote by a majority of the EEOC's 5-member bipartisan commission. Congress has vested the EEOC's attorneys with the authority to appear for and represent the commission in any case in court, but to do so only at the direction of the commission. As a result, the commission has historically considered, deliberated about, and voted on whether to file lawsuits recommended by the commission's general counsel. In recent years, however, the number and percentage of litigation matters presented to the commissioners has diminished significantly. According to one current EEOC commissioner, the commission voted on 3 of 122 lawsuits filed during an entire year. These numbers give the impression of a commission made up of potted plants and disinterested bystanders. The available evidence suggests that the current strategy is not as effective as past practices. For example, the amount of money recovered by the EEOC's litigation program in the last 2 fiscal years is lower than at any point since the EEOC started reporting this data. Moreover, the EEOC has recently suffered several embarrassing losses. Several courts have dismissed all or significant parts of several EEOC lawsuits. Other courts have sanctioned the EEOC, and the taxpayers are on the hook for the cost of these cases and for paying sanctions. And these kinds of embarrassing losses and sanctions damage the Commission's credibility. The Litigation Oversight Act may help restore the Commission's oversight of the agency's litigation program. The second bill before this subcommittee, the EEOC Transparency and Accountability Act, would provide for judicial review of the EEOC's pre-suit conciliation efforts. The civil rights laws generally authorize the EEOC to file a lawsuit only after it has been unable to secure a pre-suit conciliation agreement from a potential defendant. In December of 2013, a U.S. Court of Appeals in Chicago became the first court to hold that EEOC's compliance with this congressionally mandated obligation is subject to virtually no judicial review, and the Supreme Court is now considering the issue. The EEOC Transparency and Accountability Act would settle the issue by statute. The bill would require the EEOC to engage in bona fide conciliation, including by identifying its claims and any putative victims thereof before EEOC files a lawsuit. These provisions may preempt the sue first, ask questions later mentality that has troubled several federal judges and led to humiliating dismissals of several EEOC lawsuits. The third bill pending before this subcommittee is the Certainty in Enforcement Act of 2014. This bill would provide that an employer does not violate the Civil Rights Act if it complies with another federal, state, or local law in particular areas. Some laws restrict employers from hiring persons with criminal convictions, and the EEOC recently issued enforcement guidance that suggests that such blanket hiring restrictions may violate the Civil Rights Act. The Certainty in Enforcement Act may provide a useful fix to this conflict. Many times employers feel like they're caught between choosing to comply with one law and risk violating the Civil Rights Act. Nonetheless, for purposes of greater clarity, the subcommittee might consider a few amendments to the bill as it is presently drafted. First, you may consider limiting the bills to laws that require employers to conduct criminal background checks or credit history checks. This seems to be the primary concern of the bill. Second, you might also consider limiting the bill to allow employers to follow laws that are targeted to hiring practice in certain safety-sensitive areas like healthcare and childcare, where people are serving very vulnerable individuals like children and the sick and injured. Third, adding the language that specifically addresses disparate impact liability, that is, so-called unintended discrimination, may help clarify that the Certainty in Enforcement Act is in no way intended to sanction intentional discrimination. Thank you for the opportunity to testify here today, and I look forward to your questions.
Thank you, and thanks to each of the witnesses for your statements, and we look forward to those being broadened under questioning. Before I move to recognize my colleagues for questions, pursuant to Committee Rule 7C, all members will be permitted to submit written statements to be included in the permanent hearing record, and without objection, the hearing record will remain open for 14 days to allow such statements and other extraneous material referenced during the hearing to be submitted for the official hearing record. I would also like to ask for unanimous consent to include in the record a letter of support signed by 19 stakeholders for all 3 bills we are discussing today, including professional organizations, healthcare organizations, construction, food service, you name it. So without objection, hearing none, they'll be included in the record. I will now recognize the chairman of the full committee, Education and Workforce, the gentleman from Minnesota, Chairman Klein.
Thank you, Mr. Chairman. Thanks very much to the witnesses for being here today for your testimony. Ms. Clemens, let me start with you because I want to get at this issue of preemption, federal law, state law, and all that sort of thing that was raised by the ranking member and others. The EEOC's criminal background checks guidance states that the fact a criminal background check was conducted in compliance with a state or local jurisdiction requirement does not shield the employer from liability. That's your testimony and what we're talking about here. And yet there are numerous federal, state, and local laws requiring the use of criminal background checks. For example, the Senate passed in March and the House passed this week the Child Care and Development Block Grant Act, which requires states to have policies and practices in place requiring background checks for child care providers and prohibiting employment in federally funded child care programs of those convicted of violent or sexual crimes. So in this case, we've passed, and we hope the President will sign and all that, a law that requires states to have such practices and policies in place. So how is a child care provider or another small business supposed to choose between following state law and subjecting itself to EEOC prosecution? It just seems like that is really between a rock and a hard place. And I want to give you the opportunity to expand on that for just a minute.
I absolutely agree with you. It's those types of examples that really illustrate the difficult position that the EEOC's enforcement guidance put employers in. It's a Hobson's choice with no good answer at this point. And really I would ask, what exactly is an employer supposed to do if they conduct the individualized assessment that's contemplated by the EEOC's guidance and determine that the state or local requirement is not job related? They still have to follow it. And if the EEOC's answer is that this will never happen, that these types of requirements will always be job related, then they should have said so in the guidance so that employers could avoid, especially small employers, could avoid this costly individualized assessment. I don't think these difficult decisions should be made on the backs of private employers. They are simply trying to follow the law. They don't make the law.
Thank you. Mr. Lloyd, according to your testimony, in its reasonable cause determination, the EEOC demanded elimination of the retirement provision, extension of offers to reinstate retired partners, and the creation of a compensation fund for those retirees forced to retire early. Could we just probably have a couple of minutes here on the clock? Could you sort of briefly describe Deloitte's business model and what the effect of this would be on that? And I'm very concerned when you get something like the EEOC dictating what your business model should be. But explain why this is a problem.
Thank you, Chairman Klein. It is a big problem for us. As I said, we have an ownership structure with partners who are about 4% of our total population. And I could go into great detail about why they're real partners. And we're required to have that model, not necessarily 4%, but to be a partnership under various state regulations relating to certified public accountants and the way they can organize. Beyond that, the retirement system we have in place helps ensure that we have appropriate succession planning, that we can plan for the future, because under many statutes, such as Sarbanes-Oxley, in the audit practice, for example, we have to rotate people into the positions of leading the audits for independence purposes. And thus, it's very important to us that we have virtual certainty about how long people can serve in the role as partner, these leadership positions of all sorts within the firm, and plan so that we have orderly transitions and we groom people to move into those positions to comply with the regulations that we are subject to.
Okay, I'm about to run out of time here, Mr. Chairman. I'll yield back. Thank you.
I thank the gentleman. I recognize the ranking member. this committee, a gentleman from Connecticut, Mr. Courtney.
Thank you, Mr. Chairman. Mr. Foreman, just to sort of focus for a second on the background check guidance activity by the Commission. Again, just for the record, and I'm pretty sure you follow this pretty closely, but the Commission as a whole did actually act on this. This was not something, again, that delegated staff created in terms of that guidance. Isn't that correct?
Yes, that's correct.
Yeah, and it was a bipartisan vote of the Commission, and again, it was trying to get at what is a real life impact out there, which is that criminal background checks, if not used sensibly, can have the net effect of harming or excluding people from employment who are particularly African American and Latinos. And again, that's something that the Commission studied before it moved forward. Isn't that correct?
Yeah, absolutely. The data on that point is not in dispute, that if you implement either arrest records or criminal background histories and screen based upon that, you're going to screen out statistically significant part of minority populations. I mean, the data is uncontrovertible on that.
But it also made clear that employers are not required to just ignore it entirely. I mean, there was clear latitude that that sort of guidance allows for common sense decision making by employers, so that the nature and gravity of prior criminal conduct, the time that's elapsed, the nature of the job and health, I mean, all provide safe harbor for employers who, again, if they've got somebody they know is a violent offender, that they should not be in a, child care center or a health care facility, or frankly, almost any employment setting. I mean, isn't that correct? I mean, they recognize common sense opportunities for employers not to be helpless with information they know about individuals.
Yeah, and absolutely, in the guidance did not plow any new ground. I mean, if I could just take a moment, it actually started based upon a case called Green versus Missouri Railroad, where they said you can't take these into consideration, but there needs to be an individual determination. Does this really impact a person to do the job? EEOC then issued guidance that was approved by then now Associate Justice Clarence Thomas, saying, yes, that makes perfect sense. The case went to the Third Circuit, L versus SEPTA, and the Third Circuit said, we would like more guidance from EEOC on this so that we could actually defer. And then EEOC does hearings and develops very detailed guidance, but has its foundation in Green and what Associate Justice Clarence Thomas said was good policy, and is simply out there now so that employers know what the rules are.
So again, all I would just say is that, if there are issues that, you feel are still a problem out there, Ms. Clemens, I mean, frankly, that's something that I think that all of us up here are more than happy to present to the Commission and support in terms of them to re-examine or reevaluate how it's being implemented. But 5423 is a blunt instrument, which even Mr. Dreiband's testimony acknowledged, kind of sets in motion a mechanism which sweeps up a much more damaging path as far as what it could do to individuals who have nothing to do with the issue of criminal background checks. My few remaining seconds here, Mr. Foreman, can you talk about the claim of litigation crisis, again, in terms of what the real numbers are out there? I mean, we heard sue first, ask questions later. I mean, again, what I'm seeing is really almost the opposite in terms of how much actually goes to court.
Well, again, the data is out there that EEOC has done a tremendous job in recouping damages and filing lawsuits. There are several cases that repeatedly get played back as EEOC gone awry. And one thing I think this committee really needs to understand, if you talk about Kaplan, if you talk about PeopleMark, I think Christ is one of those also, that all of these bills would not have changed the outcome in those cases at all. Why do I say that? Because Kaplan and PeopleMark were approved by the commissioners. So it went through the process, and they approved that litigation. And in Christ, I think also went through the system, but I'm not 100% sure on that. And as to conciliation failure, EEOC's position is they engaged in good faith, reasonable negotiation, and so it would not have changed the outcome at all. But what it would do is provide another layer of litigation and another cost and prevent innocent victims of discrimination from ever getting into court if there is some procedural dismissal on the case.
Thank you.
I thank the gentleman. I recognize myself now for my 5 minutes of questioning. Mr. Dreiband, thank you for your comments. Thank you for your suggestions as well. That's what a subcommittee process is for, and our full committee chair would appreciate us doing deliberative work here. But earlier this year, I met with General Counsel Lopez and followed up with a request for documents regarding EEOC's litigation policies. I had EEOC provide me with all the class action and systemic complaints filed between 2009 and 2014. In that, I discovered that only 8% of these cases were pursued through commission approval. Can you explain to the committee how a commission that has designed to implement the non-discrimination policies of EEOC is barely involved in multiple plaintiff litigation?
Well, it's certainly been a change since my time at the Commission. I think that the current approach has essentially been to delegate in practice and in fact nearly all authority to the General Counsel to make a decision about whether or not to go forward with a lawsuit. That is not how the Commission operated when I served at EEOC. As Ms. Clemens noted, I sent up dozens, if not hundreds, of cases to the Commission for vote. And I found that by doing that, it enabled us to speak with one voice, to send a message to actual or putative defendants that the Commission's litigation was backed by the full Commission, and I think the results speak for themselves. I'm flattered that Mr. Foreman saw fit to quote my remarks at one time when I served as General Counsel, but when I served with full support of the Commission, we recovered more money for victims of discrimination through our litigation program than ever in the history of the EEOC. And what we've seen in the last couple of fiscal years is that both filings are down as well as recovery through the litigation program, and down significantly to the lowest levels since the Commission started reporting this data. So, you know, the Commission is currently free to operate how it wants to. The bills would require more involvement by the Commission, and I suppose my question would be for anybody who opposes more Commission oversight and deliberation about Commission litigation recommendations, exactly what they think these commissioners should do. I mean, the chair of the Commission has the operational authority of the EEOC by statute, but the other 4 commissioners have no operational authority at all. They don't supervise investigations, they don't direct litigation. All they do is vote on policy matters presented to them by the chair, on litigation matters presented by the General Counsel, or on occasion subpoena enforcement actions, and that's it.
So would you think that this policy as it's being carried out right now, speaking as a former General Counsel, but creates the possibility of abuse of power by the General Counsel in this whole process? Well,
I think that the current General Counsel is a friend and former colleague of mine, and I think he's well-intentioned and doing the best job he can do. I don't think, though, that having oversight by the commissioners does anything other than strengthen the litigation program by the Commission. It sends a message to the public, to potential defendants, that the Commission stands behind the decision to commit resources and to file a lawsuit, and simply creates a review of potential litigation, including some of these embarrassing losses that the Commission has suffered lately that may or may not have occurred, of course, as Mr. Foreman pointed out. But in the same way that a grand jury reviews an indictment presented by a prosecutor, the Commission has served that function very well, certainly during my tenure, and at various other times in the history of the agency.
Thank you. Let me move over, Mr. Lloyd. Recently, EEOC investigated PricewaterhouseCoopers for including a mandatory retirement age in its partnership agreements, sounding familiar to your situation. The EEOC General Counsel submitted that case to the Commission, but the Commission, by a 3-2 vote, did not approve litigation. Why is the EEOC investigating Deloitte for the same type of partnership agreement that PricewaterhouseCoopers has when the Commission already decided the issue did not merit litigation?
Mr. Chairman, I have to say I have no idea. I'm sorry that I can't answer that question.
I figured that would be your first response, but are legal issues any different in the two cases?
No, the legal issues are no different. If anything, our partnership agreement provides for more participation by partners than Pricewaterhouse's does. But essentially, we're in the same business. We have the same business model. We have the same partnership structure generally. Our age is 62 for mandatory retirement. Their age is 60. So in that sense, there's a slight difference. But we have not been given thus far any notification of the basis of the staff's determination that we violate the Age Discrimination Act, other than they believe any mandatory retirement policy based on age is inappropriate.
So then do you believe the Commission's rejection of the PricewaterhouseCoopers case set a precedent the agency should follow unless it provides a compelling explanation of why it's abruptly reversing course?
I do believe that. Yes, sir.
And that's the challenge that you have then in dealing with something that is now seemingly a precedent setter, but going over what they've already said.
It is, and you know, one thing that we very much would like is an opportunity to discuss with the commissioners themselves the reasons why they did not elect to proceed against Pricewaterhouse and the reasons why they should not elect to proceed against Deloitte.
Okay, thank you. My time is up. I now ask a representative, where's he gone? Oh, there he is, right here. Representative Takano, who has stepped into the ranking member's position here for your 5 minutes of questioning.
Thank you, Mr. Chairman. Mr. Foreman, could you comment on this colloquy on the role of the Commission and the Deloitte's interest in having its interests reviewed by the entire Commission, and maybe just comment on what you think the role of the Commission ought to be?
Yes, and I will give my disclaimer that I'm not an expert on the facts of the specific case, but what I think this represents and what we've heard today is that everybody supports the discrimination laws except when they're aimed at their client, and then they come before you and say it's not fair that we're being targeted. And why do I say that? And Chairman Wahlberg, you used the term precedent setting. Here's the reason I say that. That case is based on a precedent that was set by EEOC years ago, where they sued a law firm, Sydney and Austin, arguing that their partners were employees. That was litigation that was approved and brought by my colleague, General Counsel, then General Counsel Dreiband, and approved by the Commission. So they had a policy of doing exactly what they are doing with Pricewaterhouse. So there's not some change of the rules. They're taking existing precedent and challenging it. And at some point, the courts and the Supreme Court will say, are these individuals employees for purposes of coverage, or are these employees partners?
Well, I want to shift topics a little bit. The majority seems to be using the EEOC's recent guidance on background checks as justification for acting on H.R. 5423. It's my understanding that the EEOC guidance allowed for flexibility based on the nature of the employment. I know that we had some of this discussion with Mr. Courtney, but can you elaborate on that? The scope of H.R. 5423 seems to go well beyond the issue of background checks. What kinds of repercussions could a bill of this breadth have on the EEOC?
Again, and it was talked about earlier, if you apply that bill as written, it applies to intentional discrimination, disparate impact discrimination. A state or local government could pass a law that says women could not do X. It would be exempted under that bill. Now, there is a recognition that maybe it should be limited to criminal history backgrounds, but even that presents a problem because you're elevating local and state law over federal law Title VII was written to do exactly the opposite.
So, as you covered in some of your testimony, I'm still curious about 5423, some of the problems it would cause. In your opinion, if we went back to the quote-unquote states' rights schema to root out discrimination on in the job, what are some of the challenges that workers would face? And you named a lot of them just now. I'm just curious, Mr. Lloyd, given Deloitte Touche's commitment to the mission of the commission, is HR 5423 something that you could support, knowing what you know now?
Sir, I think that we support all the bills that are proposed. I think some of them could be improved, as Mr. Dreiband suggested, but there is guidance issued by the EEOC that's problematic in practice, and we think that things can be improved. The processes and guidance from the EEOC can be improved, sir.
One last question. HR 4959 would mandate, quote, good faith efforts to endeavor, end quote, to resolve charges by, quote, bona fide conciliation, end quote. In doing so, it would at least in part deal with issues set forth by the Seventh Circuit in EEOC v. Mock Mining, which is pending before the Supreme Court. Should Congress get involved in this issue? And I think you already answered that, Mr. Foreman.
My view is absolutely not, that we have a Supreme Court, we have exactly that issue there. The business community is making their arguments, the United States governments will be making their arguments, and probably by June we'll have a decision on what that conciliation provision means in Title VII. Why change it now?
And what exactly do good faith and bona fide mean as used as in this legislation?
Well, that's part of the underlying litigation, why the Seventh Circuit said that you cannot utilize that as an affirmative defense because, one, EEOC has absolute discretion as to whether it fulfills, the settlement fulfills the duty of Title VII. So is one more offer required? Is one more dollar required? And if the EEOC says, no, we're going to fail conciliation, is that bad faith conciliation? And the court says, you cannot adopt the workable standard, and that's the reason we can't make it an affirmative defense, as this bill would attempt to do, and as the employers are arguing in Mock Mining.
All right, thank you, sir. My time has run out.
I thank the gentleman, and now I recognize my colleague from Indiana, Mr. Rakita.
I thank the chair, and I thank the witnesses for their testimony. I always learn a lot at these hearings, and I think that's what they're about. And perhaps unlike some others that were here earlier, I try not to prejudge them. But having said that, I do want to start off by offering some time to Mr. Lloyd. In Indiana, we have a saying that it's a pretty thin pancake that don't have two sides. And I think the actual quote is don't instead of doesn't. But if you had anything else to add to the recent comments of Mr. Foreman, you're welcome to say them now for a couple seconds.
Thank you. I actually know the facts of the Sidley matter better than Mr. Foreman because I was a partner at Sidley and Austin and on the executive committee at the time the EEOC brought that litigation. And I think Mr. Dreiband made an error in suing Sidley. But in any event, I can tell you that on the one hand, we have the Sidley matter where the commission approved going forward, and I understand why. And we have the PwC matter where, based on very different facts, the commission made the decision not to go forward. And our facts are very similar to the PwC situation and very dissimilar from the Sidley situation. And I would like the opportunity, as I would have, for example, at the SEC, if the staff made a recommendation to proceed, to submit in one form or another, and maybe even visit with, to the commissioners, the facts, so that they can make an informed decision about whether it makes sense as a policy matter, as a matter of whether this is a novel issue of law, and as a resource allocation matter. I mean, who are we going to protect here by initiating this litigation and tying up our staff time on this? And I can tell you, we take votes. Sidley Partners did not vote, for example. That's a very important difference. And my guess is that if at Sidley We had had votes taken by the partners on a routine basis for such things as electing leadership that the EEOC at the time would have made a different decision and would not have authorized proceeding against Sidley.
Thank you, Mr. Lloyd.
Thank
this
you.
is to you and Mr. Dreiband. In my prior public service, I was Indiana Secretary of State, and in that great job, I had the opportunity to oversee several boards, appoint several boards, create into statute boards. Some boards, you know, were politically divided equally. 2 Republicans, 2 Democrats. That usually ended in a disaster. But some were all my appointments as a person being directly elected by the people, and then some had different varied degrees of political appointments. But they weren't necessarily partisan. It was just a way to decide things and to reflect the will of the people through their elected representatives. It seems to me in hearing this discussion that if you're having unelected attorneys, bureaucrats, whatever word you want to use, make these decisions, you're kind of tipping the scale of what the statute might have intended, the legislature might have intended in terms of the political appointments and how these decisions were supposed to be really made. Can you comment on that briefly, Mr. Lloyd, and then Mr. Dreiband, same question?
Yeah, I'd be happy to respond. I agree wholeheartedly, and it has nothing to do with the competence of the attorney or the good faith of the attorney. Speaking as a general counsel myself, you know, I many times have oversight that sometimes I wish I didn't have, but I've found that over time, that oversight and getting differing opinions from people who are experienced and have different insights, that come from different backgrounds, have different points of view, is extremely valuable. I learn things. I then make different decisions on occasion from what I would normally do.
And then Mr. Dreiband on the time I have remaining. Thank you, Mr. Lloyd.
Sure. Any law enforcement agency, no matter who they are, can become prone to overzealousness and excess. That's true of prosecutors, that's true of the police departments, and at times is true even of the EEOC. To deal with this issue, Congress created the Commission, a bipartisan commission of 5 people appointed by the President, confirmed by the United States Senate to serve staggered 5-year terms. No more than 3 of those 5 members can be of the same political party. As a result, the Commission, in the statute itself, is responsible for authorizing attorneys appointed by Title VII of the Civil Rights Act to appear in court at the direction of the Commission. Congress did not intend, and there's nothing in any statute to suggest that Congress did intend, for the Commission to delegate all of its authority about litigation entirely to other people in the agency, and that appears in practice to what has happened at the EEOC. In the same way, as I said earlier, that grand juries provide a check on prosecutors, even the most well-intentioned prosecutors, the Commission can serve and has historically served that same function at the EEOC.
Thank you, Mr. Dreiband. Seeing my time's expired, Mr. Chairman, I'm yielding back, but I also would like to note for the record that the ranking member indicated that the hearing was only noticed for 8 days. That's actually a day extra day than what the rules actually require, and I would hope that the ranking member with 25 years of law practice would have read our rules.
I appreciate the former Secretary of State's attention to detail, and yes, it was 8 days, while we were only required 7 days. I now have the pleasure of recognizing the gentleman from Virginia, Representative Scott.
Thank you, Mr. Chairman. Mr. Foreman, we've talked about the background checks. The case I remember from was the Griggs case, where they required high school diplomas, which had nothing to do with your ability to do the job, and it had a disparate impact in the community without having any relationship to the jobs. Now, this background check thing comes into practice with what's called that box you have to check, and there's a campaign to ban the box, because when you check the box, your application summarily goes into the trash. Now, we've heard of situations where it would be illegal to hire people who've been convicted of violent crimes or or people with sexual abuse. Would it be improper to have a box on the application that states violent crime or sexual abuse, as opposed to a box that generally, any felony or any arrest or anything else that would be generally applicable? It seems to me that the general box, any felony, would be overbroad and would include a lot of people that would not be prohibited from being employed. And you'd have the back to the disparate impact without any job relation. Is that true, Mr. Foreman?
I mean, that would be one way to attempt to address it. I mean, you're absolutely right on manning the box. I mean, what happens is many employers will adopt a policy that says, have you ever been arrested or convicted of a crime? If the answer is yes, you're out of the screening process and there's no individualized assessment. And part of what EEOC's guidance is trying to do is say, let's look at the person. Is this person rehabilitated? Is it proper? Can this person do the job? Is it reasonably related to the job? That's really all the guidance is trying to do. In going back, as you said, to Griggs versus Duke Power, that was a GED that screened out minority employees, and the court there found that it was discriminatory, developed a disparate impact analysis, and we have discovered there are other things that do that. And that's what the criminal guidance is supposed to do. The problem with the proposed bill then, it then takes and exempts state and local governments from basically the requirements of Title VII. When it was passed, that was vital to Title VII. So let's not understate what the proposed bills are doing. You are rewriting one of the most historic civil rights statutes of our history in a way that doesn't add any benefit.
Mr. Foreman, can you state the present law on discrimination cases as they relate to sex discrimination, what you can recover as opposed to other forms of discrimination, race, religion, national origin? Are there differences in what you can recover?
Well, they're absolutely different in terms of what EEOC can recover as opposed to an individual who may bring a claim under, and I don't want to get bogged down in terminology, but 42 U.S.C. Section 1981, there are uncapped damages. The jury will award whatever the damages are that were the cause of the discrimination, whereas under Title VII, they are capped according to the size of the employer.
Well, is it different in Title VII from other forms of race discrimination? They're uncapped under 1981, but not uncapped on others?
1981 only applies to race discrimination-based claims. So if you bring a race-based claim under Title VII in an employment context, you are capped, but you are also capped in sex discrimination, any of the protected coverages under Title VII. Did that answer your question?
I think, yeah. Well, there's we have the Fair Pay Act for sex discrimination cases. Can you say what that would do to improve the situation? The Equal Pay Act?
Well, the Equal Pay Act has a different regiment that does not have the same level of damages. I mean, the reality is that the discrimination law should provide whatever damages the person suffered, whether it's sex-based discrimination, race-based discrimination, and I think the Fair Pay Act is attempting to get at that, to say if you prove that you're a victim of intentional discrimination, then you should be entitled to whatever economic damages that discrimination caused you.
The gentleman's time has expired. Thank you. And now I recognize the sponsor of H.R. 4959, my colleague from North Carolina, Mr. Hudson.
Thank you, Mr. Chairman. Mr. Lloyd, I've read your testimony, and I have to tell you, I'm really deeply concerned that at a time when with limited resources. EEOC has some 77,000 pending claims they're looking at that they've made a decision to go after your firm and the mandatory retirement age when no one's filed any sort of complaint where there's been damages. This is a decision made by a group of partners who manage this firm. And the irony of it is, if the firm decided to comply with the lawyers at the EEOC's request, it would require a vote of the partners to make the change. Frankly, it's outrageous to me. But my question to you is, do you believe that if the EEOC continues to pursue this line, this matter, that it would involve a major expenditure of resources by the EEOC and or trigger the public controversy test requiring a vote of the Commission?
Well, I strongly believe that it would meet those tests as well as the test that this would be a novel application of the law for reasons we discussed. It would require extensive expenditure of resources by the EEOC, not court costs and things like that, but when you think of valuable staff time, this would be major litigation. We would defend ourselves vigorously because we think they are wrong as a matter of law and as a matter of fact. And so the EEOC staff devoted to that litigation would be fairly extensive, and those people would not be able to pursue this 100,000 claims or charges that they get of individuals who need real protection. I mean, we are talking about at Lloyd people who are real partners, but beyond that, very highly compensated. And we've done a study in response to this that shows that our partners who have retired, been required to retire in the last 5 years, have been overwhelmingly, as I said in my testimony, white males. And yet our population coming along through the staff and eligible to be admitted to the partnership is much more diverse. And over the last 5 years, while our white males have been retiring, 88% of our retiring partners have been white males over that last 5 years, and only 12% women and minorities. On the other hand, the newly admitted partners during that same period of time have been 41% women and minorities and 59% white males. And so the operation of the mandatory retirement system has actually caused our partnership to become more diverse. And it clearly will in the future. Our population of people below the partner level is incredibly diverse. And they're wonderful performers, and they are going to advance to partnership. But if we were not able to have this mandatory retirement provision that we do have, age 62, then we have a limited number of partnerships. And so the opportunities for the women and minorities would be limited. Not foreclosed, but they would be limited. And to me, that's a perverse result when you think of all of the objectives of the statutes that the EEOC is tasked to enforce, and objectives that we believe in quite strongly. I mean, we do our own internal disparate impact analyses, and we make sure that we are doing the best job we possibly can to provide equal opportunities and development opportunities for our women and minorities. This would hinder that.
Yeah, I appreciate that. And Mr. Chairman, I do believe the cost involved as well as the public controversy test certainly comes in play here, and I would hope that the EEOC, if they choose to pursue this, will move to a vote of the Commission, because I think that's what the statute requires. Changing direction here quickly, Mr. Dreiband, my bill, H.R. 4959, has a provision clarifying the EEOC's conciliation efforts must be in good faith and are subject to judicial review. Professor Foreman's testimony criticizes this provision as undermining the separation of powers because the Supreme Court has granted review on this very issue in the EEOC versus mock mining. Do you believe it's appropriate for Congress to clarify what the duty of the conciliation entails?
Well, I don't see anything wrong with Congress clarifying the matter if Congress decides to do that. Congress is an independent branch of the United States government, and it's not in any way limited by the fact that a lawsuit is pending before any particular court, including the Supreme Court of the United States.
Appreciate that. Trying to use my time as efficiently as I can. Ms. Clemens, thank you for your testimony. I've read that as well. You described instances of what could be characterized as abusive investigatory tactics at EEOC. You also described situations where EEOC would make a predetermination settlement demand, and when the employer declined, the EEOC would quickly drop some of the charges. The EEOC Transparency and Accountability Act, which I've introduced, clarifies that the EEOC must conciliate in good faith and provide specific information to the employer about the factual basis of the allegations and the affected employees, and the EEOC's conciliation efforts are subject to court review. How would these provisions alleviate the problems you've seen at EEOC investigations and mandatory conciliations?
Seeing that time has expired, and yet being a sponsor of the pieces of legislation, I will ask you to respond as quickly as possible, and the rest could be put in writing.
I think it's important for the committee and the EEOC to recognize that employers, when faced with appropriate information from the Commission, are more than willing to come to the table and try to fix problems that the Commission sees. What's happening now is that employers don't have enough information to really evaluate the strength of the EEOC's findings, and it makes it difficult for employers to pursue negotiations in good faith. And so one of the things that I think your bill would help is provide that information so that both parties can come to the table in good faith with the same information about the employment practices that are at issue.
Great. I thank the chairman for his magnanimity and discretion there. Thank you.
How's that defined in North Carolina? I'm not sure about Michigan either. So thank you. I thank the gentleman. Thanks to the panel. We appreciate your very considered testimony, answers to questions, ideas, and that again is the purpose of this subcommittee. Now I'd ask my ranking member to conclude with his concluding remarks.
Thank you, Mr. Chairman. Again, thank you to all the witnesses for the time you devoted here this morning. Again, I understand that while I was over at the Agriculture Committee, someone raised a question about whether or not I was challenging whether the committee had followed the rules. That was not my point earlier. There's no question 7 days is the rule. The issue really is that this is, I think, our third hearing or possibly our fourth hearing on EEOC over the last 2 years or so. Once the chair was the witness, but since then the scheduling of the hearing process has basically effectively excluded the commission from participating in what I think would be a helpful dialogue in terms of trying to express frustrations that members may have, constituents may have. Because in my opinion, a legislative response, which is really, what's on the agenda here today, is a fool's errand. I mean, the chances of any of these bills getting enacted in the 113th Congress are about as remote as the Red Sox getting into the playoffs. And if any of you follow the standings, they've been mathematically eliminated. So it is impossible. And so, we have this exercise for whatever purpose, and it again is going to accomplish nothing in terms of changing the law. And what I think would be a better use of time would be to actually engage with the commission and the department. We have tangible results in the last 9 months since Secretary Perez has taken over, where he has listened to bipartisan concerns that members have raised with the department in terms of department operations, and he has responded to those with real tangible results. And again, I think having legislation which was just filed, and certainly the last case, within just a week ago, and expect that to somehow advance the ball here in terms of, really trying to improve the agency's performance. Again, I just think is, with the productivity of this Congress in terms of the amount of legislation that's actually been enacted, just not, in my opinion, the most effective use of time. And again, the 50th anniversary of the Civil Rights Act is something that we observed as a nation this year. I think, again, Mr. Foreman helped try and sort of rebalance the record here today in terms of showing that there still are people who suffer from racial and civil rights violations in this country. The EEOC has a very necessary role in our economy, in our country. And what I think hopefully this committee will do is come up with strategies that, in my opinion, does not trample on the mission of Title VII and the Civil Rights Act, but in fact, in a measured, balanced way, move our country forward, which is really the best way to celebrate the 50th anniversary of the Civil Rights Act. And with that, I yield back.
I thank the gentleman, and I take his points. We're also celebrating Constitution Day today. That's an important document as well, that I think gives awful lot of direction for what we are to do in Congress. You mentioned Boston. I'll mention the Tigers right now. And we're hopeful that they have a better opportunity of being in the World Series. But that's not certain. It could change this weekend. There are at least 384 bills that sit over in the Senate right now that have been passed after significant effort, after this body has spoken. Much of that wealth of legislation is bipartisan to some degree. That sits over in the Senate without any action. We don't reasonably expect them to take action on it, sadly. But we certainly expect us, and as we have opportunity, we expect us to take action here and address issues that have perked to the top with great concern, and that's been the case. We've had the EEOC over here. I've had the EEOC in my office. We've sent letters. We continue to have concerns that are expressed. The overriding intent of Congress in putting the EEOC in operation was to clearly give the opportunity to make sure that unnecessary, well, let me change that. I was going to say unnecessary time was not spent, but I'm going to say that all necessary time would be spent on making sure that discrimination did not happen, that people were afforded, regardless of who they are, what they believed, the color of their skin, their gender, their disabilities, were not discriminated against, and that complaints were brought before a commission. And we established a commission to be a commission. That was some latitude to decide how they functioned to some degree, but a commission to clearly make decisions that had impact upon equal rights and opportunity and the way businesses functioned. And so I guess today is, I hope, not an exercise in futility, but a laying down, an establishing a claim by Congress on its concern that issues of concern be addressed. And if there are better ways of dealing in enhancing this legislation that's been put forward, we're certainly willing to look at it. But when you have 70,000 complainants expecting some response by a commission that is a backlog right now, and you have other cases that are being initiated without complaint, I think that's a problem we ought to ask questions at the very least about. And that the EEOC ought to know that there are members of Congress on this subcommittee, on a full committee, and in Congress at large that want those issues of concern addressed and not just carrying on the same old, same old. When you have actions without employee complaint, when you have uncertainty, inconsistency being brought into the mindset of businesses, employers, and employees attempting to understand the system, we ought to address that concern, at least ask questions. And hopefully the EEOC is listening. They certainly have an opportunity to respond, and I'm sure they're listening, respond in letter to us, expressing concerns, expressing ideas, some that have been addressed today here already by our witness panel of suggestions on how legislation could be addressed to go forward. The hearing, at least, as I said, lays a claim to carrying on our concern. Whether it is successfully concluded with this session of Congress or whether it establishes a base to pursue more aggressively to conclusion in next Congress, I think that's an important opportunity and responsibility of this subcommittee. Having said all of that, we will look forward to the response as well as carrying on further. I again want to thank the panel for being here. I thank my committee members for their attention today. And there being no further business, the subcommittee stands adjourned.